And now we have the Honorable Member, Mr. Mohabir Anil Nandlall, to make his contribution.
Thank you very much, Mr. Speaker. Mr. Speaker, I want to begin by endorsing the comments made by my colleague, the Honorable Robeson Ben, when he said that in this debate so far, though the other side has indicated their intention to support, well, not the bill, but the concept, I believe that this debate has become very discolored by the extraneous matters that we have allowed to infect this debate. And as a result, Mr. Speaker, persons, the Guyanese population, listening to us would have lost completely the importance of this bill. And Mr. Speaker, what I first wish to do is to bring back into focus the importance of this bill so that our people can understand what we are trying to do by this bill. Let me also say, Mr. Speaker, and to reiterate the point already made, that there was nothing stopping the other side from bringing a bill of this type. But don't tell me 23 years have passed. That's not a sensible argument. You want this bill, you appreciate the importance of it, and you had 5 years, and the fact of the matter is that you did not bring it, and we decided to bring it. And that is what the record should reflect. And Mr. Speaker, it's not that they didn't, it's not that the other side do not appreciate the concept of a single window, because they did bring a bill. They did bring a bill capturing the concept in a miniaturized manner, and the bill is the Custom and Trade Single Window Act of 2019, and here they were integrating very small number of agencies in a very narrow and precise area of activities, that is Customs and Revenue Authority, but using the single window concept. But you know what? Even in its narrowest form, you know what you did? You passed the bill. President Granger assented to the bill, but the minister never issued the order to bring the bill into operation. So this bill is on the record of the laws of Guyana, and it is non-functional. That is your record, and that is how efficient you are. Here what we are doing, we are bringing a comprehensive bill stretching across the entire relevant public sectors, and despite your objections, we are willing to delay it further yet, so that you can have an opportunity to contribute in a more constructive way in the select committee. But Mr. Speaker, any person who has ever had the opportunity or the occasion to apply in Guyana, whether in country or in tongue, meaning in the tongue or in the rural areas, for building and planning permission, can easily relate to you the ordeal and the agony that they have to endure in getting these permission plans, licenses granted. It is an agonizing, tedious, frustrating process, because depending upon the type of construction, depending upon the geographic area that you wish to construct in, and depending upon the use that you will use the construction for, you have to go through a number of agencies. Each one has to play a role, And the sad reality is that you spend an extraordinary amount of time at each step or each link in the process. And Mr. Speaker, the bill outlines the various agencies in a schedule to which it applies, and which now is the correct procedural journey that one has to travel. So let me quickly go through Schedule 3, second schedule of the bill, and just listen to the agencies. You have to get permission from Central Board of Health, Ministry of Public Works, River and Sea Defense Board, Guyana Lands and Surveys Commission, Environmental Protection Agency, Guyana Fire Service, Guyana Civil Aviation Authority, National Trust of Guyana, Guyana Office for Investment, Land Registry, Deed Registry, Water Incorporated, Maritime Administration Department, Guyana Forestry Commission, Neighborhood Democratic Councils, and all local authorities, including municipalities. All of these, depending upon the type of construction you are about to engage in or the geographic location of your proposed construction, you have to travel a journey that involves all or many of these agencies. And at every step of the way, you are confronted with administrative red tapes, obstacles, hurdles, and I dare say, corruption before getting your permission or...
So, Honorable Minister, we have...
You have, Mr. Speaker, this horrendous, bureaucratic, frustrating journey. And I know this from real personal experience. As a result, many constructions, projects, investments have been aborted midway because of frustration and because citizens are unable to travel this torturous journey. The other alternative is, Mr. Speaker, that many of these projects are completed without these permissions being granted, and that is the reality. Mr. Speaker, what this concept captured in this bill does is to collapse all these agencies into an integrated machinery. And the single window unit is the engine that will drive that process of your applications or requests for permission from the beginning to the end. And all you have to do is to come back to that single window for your approvals. This, Mr. Speaker, is a remarkable initiative that is being implemented. And you cannot have a rational mind and be opposed to this, Mr. Speaker. This cutting out years of red tape, millions and millions of dollars of investment, time and energy. Mr. Speaker, what people don't understand is that when you are investing in a certain level, you have to have financing. These financings have to come from commercial institutions. So you go to the bank, you borrow, the money is disbursed, but you can't begin to put a truckload of sand on your land because none of the permissions which you have is being approved, and you can do nothing to accelerate the process because of the bureaucratic incompetence that is so institutionalized in the system. So you have monies disbursed to you from the bank, you can't spend it, but your installment becomes due, your interest becomes due, and after a while, Mr. Speaker, your project becomes a financial nightmare. And that's why I'm saying many people had to abort projects, denying this country of millions of dollars of investments, denying hundreds of jobs to Guyanese that these projects at the construction and other stages would have created. This bill, Mr. Speaker, you don't understand the bill. That is why you stood there and did not make sense. This bill, Mr. Speaker, it seeks to bring all of this together in this institutionalized way in order to collapse it, to make the process an efficient one. And that's why the bill And Mr. Speaker, the PPP didn't pull this bill out of a hat. We had a consultant who did, first of all, a qualified person who studied these types of institutional machinery. This consultant engaged all the players along the way, all the agencies, important stakeholders, before a concept paper was prepared. And that concept paper, in the form of policy directives, culminated in recommendations. And it is those recommendations, Mr. Speaker, that form the drafting directives and imperatives that resulted in the crafting and final result of this bill. So, Mr. Speaker, many a times we speak about doing business easier, improving our administrative efficiency in every sphere of government. This, Mr. Speaker, is a striking illustration of our government making strident steps to achieve that objective. Mr. Speaker, this bill, therefore, is long overdue. Which the bill brings to be implemented. And the Honorable Minister took his time, the Honorable Colin Crowell, and went through the bill and the system that the bill outlines. Both manually and electronically, submissions can be made. So you can be in Timbuktu or you can be in Georgetown and submit your application. And it begins to process immediately. And it travels that journey. Now, I heard a lot about the undermining of the autonomy and functional authority of local government institutions. Now, that's a very uninformed opinion expressed. Persons quoted the Constitution and everything else. Mr. Speaker, the truth of the matter is that this bill will not interfere with or deprive any of the authorized statutory agencies from performing their functions. Not at all. It will not usurp the power of the fire service, for example. It will not usurp the power of the city engineer department. It will not usurp the environmental protection agency. It will not usurp the neighborhood democratic council. All it will do is that it will police the process to ensure that those agencies who are assigned responsibilities in this process discharge them in accordance with law and discharge them competently, but most importantly, efficiently. Efficiently. And that is why in the regulations, each type of application, a time frame will be delimited from beginning to end. And it is also expected that the regulations will stipulate the particular time frame that an application or a request will spend at the different agency linkages in this complete chain. And it will have a mechanism in it that if the agency does not determine the particular application before it within a time prescribed, then that application will be deemed to be granted. A provision or a mechanism which we used in the Condominium Act. The intent is that no bureaucratic delay will be tolerated to the detriment of the investor or the man who is making the application. Whatever bugbear is in the agency, the citizens of Guyana will benefit from it. They will not suffer a detriment as a result of it. How can anyone find that objectionable? And that is why, Mr. Speaker, we want this bill to be passed with every convenient speed, because a lot more work has to be done. We have to build the administrative portals. We have to do the regulations, and that is why the bill has a provision that speaks to it coming into force by an order of the minister, because we have to ensure that all the administrative protocols and regulatory framework are in place to ensure when the machinery of the bill begins to run, then it has the tracks to run and it has the regulation by which it will be guided. So, Mr. Speaker, but the bill has to be passed first before we can start to begin those processes and finalize them, not begin them, because work has begun already. Mr. Speaker, I heard a lot being said about the governance structure. Let me put a couple of things on the record. I don't have a problem with that. I don't need you to trust me. You didn't vote for me. The people of Guyana elected this side to govern this country, and govern we shall. So, Mr. Speaker, let me debunk this concept that ministers must not be empowered under legislation to perform statutory functions. And there is this notion that's being peddled on the other side, that if ministers are resided with some power, that's political patronage, and that would lead to some abuse of power. Let me reject that for the record. Mr. Speaker, we on this side have been elected by the people of this country to exercise governmental power, and ministers appointed are going to exercise those governmental powers. You know why? Because we are answerable to the people. We are answerable as a collective to this House. Article 106 of the Constitution, an article with which you ought to be familiar. It says the Cabinet is collectively responsible to the National Assembly. So you want to hold Colin Crowell, the honorable member, responsible to the National Assembly, but you don't want to give him the power to perform the functions under this act? You want to give the leader of the opposition nominee? You want to give some abstract entity? That will not be tolerated either on this floor or in the select committee. The minister who is charged with the responsibility will be allowed to discharge those responsibilities. That is accountable government. That is transparent government, because you know the people of Guyana will know whom they have to hold answerable. They can vote against him if they wish, if they think that he has misbehaved, if they think that he has performed his duties inadequately or incompetently. But when a public officer goes there, or a non-elected agency goes there, they are not answerable. They are not going to elections. They don't come before this National Assembly. Colin Crowell does. Suzanne Rodriguez does. They are the ministers. You can grill them how much you want, but you cannot grill them and hold them responsibility when they don't have the power to perform the functional responsibility that you want them to account for. That is democratic governance. So let me make it very, very clear. This government has no apologies for, by law, equipping ministers with powers that are democratically across the globe ascribed to ministers. We have done nothing extraordinary in this bill, nothing at all. So I want to make that point very clear. This bill, we looked at other bills. In Canada, the consultant is based in Canada. Canada is widely regarded as a democratic country. And this bill was informed by experiences from Canada and different parts of the Caribbean, as well as we also took guidance from your bill, the Single Window, the Customs and Trade Single Window System Act. And we are not hesitant to admit that. We admit it fully, because when we went through this act, it has a reasonably good structure. So we drew from it. You don't have to invent the wheel whenever you have to do something. Mr. Speaker, the appeals, big hue and cry has been made about the appellate process. Now, first of all, every first-year law school student would tell you that any decision of a public officer is judicially reviewable once it arises out of a statute or it affects the public interest. Anytime any public officer, being a minister, being any other public officer, being a permanent secretary, or being any technical officer, once he's exercising statutory power, that decision is reviewable by a judge of the High Court in judicial review proceedings. It matters not what the statute outlines as a process. You can still go to the Judicial Review Court. Our Act says that despite whatever, our Judicial Review Act, section, I believe, 13, it says that despite whatever alternative remedies may exist, any person affected by the decision of a public officer can come for judicial review. So let me disabuse your mind. You don't have to wait for the appeal process in the legislation. You can go to the High Court immediately, at any stage of the process. At any stage, if they refuse to accept at the beginning of the single window, if you present your plan right there and they say, no, you haven't even begun the process, and they say no, you go to the High Court. Of course, you got to get a proper lawyer, Mahipol. And a judge of the High Court will review that decision to refuse the acceptance of your application at the commencement of the process. So that's the first thing. Mr. Speaker, the appeal, the Constitution, the bill says that the appeal is final. Now, statutes, and the lawyers here will know, Mr. Ramjatan is here. He is an experienced lawyer. He will tell you that Parliament has attempted many, many times to use linguistic mechanisms and formulations such as that this decision is final. The minister may determine his application as he deems fit. This decision shall not be appealed. Those are what are called exclusionary clauses. They purport to create on their face what is called untrammeled discretion. Ouster clauses. Mr. Ramjatan will tell you that none of these have ever succeeded. The courts always find a way of reviewing. You can write 1,000,000 times in a legislation that the decision of some administrative tribunal is final, and the courts will tell you, we will review it. We will review it. So, Mr. Honorable Member Mahipol, it goes without saying that you have access to the courts to review any matter here. Now, great objection has been taken to the minister having this power to declare a particular project a matter of national interest. And much criticism has been leveled in relation to that. The truth of the matter is that the executive is elected to govern. There are certain matters that inalienably reside in the executive domain of governmental responsibilities. There are certain matters that are inalienably resident in the judicial arm. The judicial determination of matters can only be done by the judiciary. If tomorrow we are to pass a statute here that seeks to assign that responsibility to a tribunal outside of the judiciary, it will be struck down as unconstitutional. So there are certain policies, directives that are inalienably that of the executive. One of them is to determine matters of national security and matters of national interest. So when a minister is assigned a function to determine a matter of national interest, he's performing an inalienable executive function under the doctrine of separation of powers. Look at the Acquisition for Public Purposes Act. That act empowers the Minister of Public Works to determine what is a public work and to acquire private properties, if private properties are required to be acquired for the accomplishment of that public works. Is the Public Works Minister determines that. And how do you qualify what is public works? It's a matter of national interest. So there is nothing, absolutely nothing unconventional or unorthodox for a minister of the government to determine what is in the national interest. That is a ministerial function. That is a functional responsibility of the executive government under the Westminster Constitution. You can put that power nowhere. Where you want to put that power? So if an appeal committees go rogue, are you telling me that a sitting government that enters into international transactions for the construction of a big project involving public health, involving national importance, a rogue appeal committee can refuse to give planning permission and the government remains a sitting duck? Is that how you want to govern a country? No, my friend. Governments are ultimately responsible. It's a risk that every government must take. That is the nature of government. So when a national project comes, and if they, in a remote possibility, it's not going to happen every day. You're not going to have a committee acting irrationally. But in that rare eventuality that you have a committee going rogue, you must have a fallback position in the natural interest. If we are doing joint relations, joint projects with Mount Sinai, as we are actually doing, and those people, we sign agreements with them, and we take international money from international financial institutions, and we are to build a joint hospital with them, and the project is, everything is okay. We have commitments on the international agreements, and if there is a committee that goes rogue within this governance structure, the government is a sitting duck. That's what you want to come into government to be, a sitting duck government? Well, we are not a sitting duck government. We reserve that power to take what we consider in actions in the national interest. And we will not abdicate that responsibility. When the people elected us to govern, they give us that responsibility and that power, and we will exercise it. So that is the first thing. And you will note, you see, when we read things hurriedly and we don't assimilate, you know, we read it carefully, you will see that the minister doesn't have a power to overturn the appeal tribunal. The minister doesn't have a power. What the minister has a power to do is to declare a particular project a national interest project. And that's all that minister has to do. The minister then brings it to cabinet, the entire government. It's not one minister. It's the entire government now will review that project. Comrades, governments review projects of that type every single day. When you were in government for 5 years, how many national projects you didn't review at cabinet? Before you go to procurement, you had to do it. Well, you didn't have much projects, honestly.
And they went straight.
You didn't have much project. Every government must have that power. We're not going to alienate that power from ourselves. So, and the minister has been given, I have a series of legislation here that I extracted. For example, the Guyana Tourism Act. Read the Guyana.
Honorable Minister, I have one standing order I've extracted, so it says that you will need an extension of time.
Mr. Speaker, I'd like to ask for an extension of time for my colleague member. Anil, 10 minutes, 15 minutes? 10 minutes, please.
The question is, the Honorable Minister be given 10 minutes? Honorable
Thank you.
Minister.
So, Mr. Speaker, the Guyana Tourism Authority Act is one piece of legislation of many, I'm going to give you more, where a minister has a power of review over decisions made by a tribunal. So you have one example here. Then you have, Mr. Speaker, the Financial Institution Amendment Act of 2018, passed by this government, your government, 2018, where the Minister of Finance is given review power over tribunal. Then in the Petroleum Exploration Act 1986, passed under your government again, the minister has a review power to review applications made for an extension of a license issued under that Petroleum Exploration Act. I give you those examples to show you where ministers have powers of review and appeal. Here we are not giving the minister that power. We are giving the cabinet that power, only to be exercised in a matter that the minister declares to be a matter of public national interest. What is wrong with that? When we are, as a government, is answerable to the people of Guyana. We made promises. We have a manifesto that we are working with. We have to account to you. We have to account to you in this house when our projects fail. But you don't want us to give us the power. Comrades, you cannot hold us accountable in relation to powers that we can't exercise. You can't have it both ways. It's either you give us the power, give us the responsibility and hold us accountable, or you don't want us to have the power, then you can't hold us responsible. But democratic, accountable and transparent government dictates that government must have those powers, and government must account to both the electorate every 5 years and to the National Assembly at periodic intervals in relation to the exercise of those powers. Mr. Speaker, the other issue that I want to speak, so that takes care of this big controversy about cabinet being this what somebody said, totalitarian. People are using concepts in this house without understanding what they mean. Totalitarian sounds, perhaps sexy, so we use it. But if we begin to talk about totalitarian, as my sister, the Honorable Onesh Waldron, did, you get offended. But I don't want to waste my time dealing with that, because those facts are well established. Mr. Ramjatan will tell you that elections were rigged from 1968 to 1985. He campaigned against that. He fought cases against that. Look at he putting his face on. Remove your face and let the young lady see you. You know that. Tell them about totalitarianism. Mr. Speaker, reference has been made to a proposed set. Oh, my friend Mr. Henry. Again, not understanding concept. Mr. Speaker, the Amerindian Act is a legislation that is sui generis. Your Honor, you wore another hat and you spent a lot of your life agitating in the Amerindian communities, and you may have played an instructive and instrumental role in the coinage of the Amerindian Act. And you know, Mr. Speaker, that that act is sui generis, in that it creates this big landmass and it has its own governance structure in relation to that. Mr. Speaker, you know that that system of governance is different from our system of governance in the rest of the country. So the rest of the country, at the local level, we have municipalities and we have neighborhood district councils. In that structure, you have village councils and Tushau National Council and so on. Completely different. That I took the time to read the schedule of the agencies that are going to be interlinked in this integrated with one window system. You hear me say anything about the Amerindian Village Council? Because this act does not apply to the Amerindian District Council. The provision that is now being inserted as an amendment is simply to iron out the bureaucratic conflicts or administrative conflicts that can arise between this act and the different pieces of legislation that this act will relate to. For example, the Mayor and City Council Act. For example, the Local Government Organs Act. For example, the Guyana Fire Service Act. Those are the Environmental Protection Agency Act. Those are the acts that this machinery that is being created now will interface with. So in the event that there is a conflict between this bill and any of those acts, this one must prevail, because this now will be the governing machinery that will administer or administrate the processing of these permissions and certifications that are being required. So that is why that is there. The other issue, Mr. Speaker, they want to add an appeal to the CCJ. Now, that's born out of ignorance, Mr. Speaker. There's no other way of putting that. Now, the Caribbean Court of Justice is our apex court. It has its own charter, its own statutes that govern its jurisdictions. Its jurisdiction. The court has two principal jurisdictions. One, a treaty jurisdiction to adjudicate on treaty matters. And then it has an appellate jurisdiction. The appellate jurisdiction can only be activated in respect of appeals filed against Court of Appeals in the territory to which it applies, or which the court sits as a final court. Check the Act section 7, 8, and 9. You can only appeal decisions coming from the Court of Appeal of the various states. When this appellate tribunal within this bill makes a decision, that is not a decision of the Guyana Court of Appeal. So an appeal cannot lie there. And Mr. Mahipal, as much as you would like it to happen, that's a final court. It's a serious place. You just can't determine that you will give the people work. You decide one Sunday afternoon, you have nothing to do, and you go rope in the CCJ to give them an appeal to be heard. It don't operate like that. And this should not be let out in this assembly. The CCJ might be very offended. So, Mr. Speaker, the CCJ, they proposed appeal going to the yes. Now, Mr. Ramjit, that makes sense. Finally, a rare moment. So if there is a judicial review application, yes, and it travels all the way to the CCJ, then it travels all the way to the Court of Appeal, and you are aggrieved by the Court of Appeal decision, then you go to the CCJ. But what Mr. Mahipal is proposing is to leapfrog the appeal from the appeal created, the appellate process created in the bill, straight to the CCJ. That is simply impermissible and absolutely illegal. So, Mr. Speaker, that can't fly. The other point in the proposed amendments, again, I want to take my time to show theoretically and in principle why it can't apply. So they want appointments to be made by the Appointments Committee of the National Assembly. Mr. Speaker, again, I go back to basic. Our Constitution embraces the doctrine of separation of powers. Listen to me, Frank. Under that doctrine, legislative functions and scrutinizing functions of executive functions are performed by the Parliament, the National Assembly. Only the Constitution can vary that. And the Constitution has done so by empowering the Appointments Committee to make appointments. But only the supreme law, the Constitution, can enlarge the role of the National Assembly or the Parliament outside of its assigned, ascribed functions under the doctrine of separation of powers. An ordinary legislation can't convert this House into an appointment agency. It cannot. It would be ultra vires the Constitution. It would be in abrogation of the doctrine of separation of powers. Parliament's core function is not an appointive or an appointment one. Its core function is legislative and to scrutinize government business and to discuss policy, not to make appointments. The Constitution has enlarged that functional responsibility in a couple of cases to make appointments. Only the Constitution can grant further extension. No ordinary legislation can do so. So this amendment that you are proposing here to have the Appointments Committee appoint persons to this appeal tribunal will not fly. It is unlawful. It is unconstitutional. My predecessor, Mr. Basil Williams, attempted to do that. From this floor, I said to him that he was wrong. He attempted to do that in relation to the AML-CFT Amendment Bill. Yes, I'm wrapping up now. And he sought to give the Parliament the power to appoint the AML-CFT authority. I said then, we said then on this side, you are wrong, Parliament cannot appoint these people. And he went ahead with the appointment, and the Caribbean Financial Action Task Force told him that he got to go back and remove those repugnant things from the legislation. And he had to do that. So, Mr. Speaker, I hope that I have achieved the core objectives of my presentation, which is first to highlight the merits of this bill and to remove the discoloration that has penetrated in it, and the people of Guyana now understand the importance of this bill, and also that I have corrected some of the errors being peddled from the other side and disabuse the minds of my honorable member on that side of the many misconceptions that have affected and impaired their presentation and their outlook in this matter. Mr. Speaker, I support my ministerial brother, the Honorable Colin Crowell, in that this bill be sent to a special select committee for a period, Mr. Speaker, of 1 month. Thank you.
Thank you very much, Honorable Attorney General and Minister of Legal Affairs. And now to